Welcome to Legal Lines. I'm the host of Legal Lines, which is brought to you by the York County Bar Foundation. My name is Tom O'Shea, and my guest today is Stephanie Seaton, the Executive Director of the York City Human Relations Commission. Welcome, Stephanie.
Thank you, Tom.
And the very first question that I am going to have is, what is the Human Relations Commission?
Well, the York City Human Relations Commission is a department within the City of York's government. We are the department that enforces the Human Relations Ordinance, which is Article 185 of the city's codified ordinance. And our mission is to provide equal opportunity to all citizens through education, outreach, and enforcement efforts.
All right. Now, before we get into exactly what you do, your position is the Executive Director. How long have you held that position?
I've held the position of Executive Director for 5 years.
And prior to that, did you work for the Human Relations Commission?
I did. Prior to that, I was a housing investigator and the education outreach coordinator at the commission.
And one of the, you just mentioned the 3 programs that are in your mission statement, education,
Yes.
outreach, and enforcement.
Yes.
What I'd like to talk about first is enforcement, and that's probably because this is Legal Lines, and there's a legal procedure to go through, and that's what attorneys find the most interesting. But we'll touch on the other 2 topics as we get toward the end of the program. So with respect to enforcement, exactly if there is an issue, how is it enforced?
Okay. We have areas of jurisdiction that we cover, and what we do is enforce the ordinance as it pertains to illegal acts of discrimination. And the areas that we cover are employment, housing, and public accommodation.
Okay. Could you define, I think employment and housing are relatively clear. Public accommodation, what exactly does that refer to?
Public accommodation is any place where you would go in the public to receive services, the mall, corner store, a bus, any place where you access services. You can go into a business to access services, and so that covers
So that would be the subject matter of jurisdiction.
Exactly.
Okay.
Exactly.
And there would be prima facie elements if someone were to file a complaint.
Yes.
And could you tell us what those prima facie elements are?
Yes. In order to file a complaint of discrimination, it must be filed within 180 days of the alleged discriminatory act. It must be jurisdictional geographically in terms of it being within our area of jurisdiction, which is the city of York. There are certain circumstances where we go outside of the city, and that's in a case where the decision-making was in the city, or the human resources is located in the city, those types of situations. So it must be timely filed, it must be within our jurisdiction, there must be an act of harm. What occurred? Were you denied something and you believe it was based on a discriminatory reason? You must be a member of a protected class.
Right. Now, can you define protected class for us?
Yes, protected class are the areas under which people are protected. So, for instance, if the discriminatory act, if you believed it was based on your religion, on your sex, on your race, a disability, your family status, which is the presence of children under 18, sexual orientation, national origin, ancestry, age, if you believe that what occurred based on any of those protected classes, then you could bring forth a complaint.
So it seems to me that there are a number of protected classes that some people might not even realize that they would fall into.
Yes.
For example, family, someone I would suspect a family that might not get an apartment because they have children might fall into a protected class.
Yes. And familiar status is specifically for housing. It works for housing. It's protected in housing, and that is the presence of children under age 18, and it's illegal to deny someone housing based on the fact that they have children. And it has occurred frequently throughout the community. It's hard to find housing, especially if you have a lot of children. They may say, oh, we don't want any more than 2 children, or if you have children, you can't live on the 2nd floor of an apartment because you'll make too much noise above the 1st floor tenants. they apply different terms and conditions. If you have children, your children can't be outside after this time, or if they use the community room, you have to be present. Just applying different terms and conditions based on the presence of children. So legal.
Okay, so if somebody has a complaint where they seek help from the commission, exactly what is the procedure that they would go through?
Well, the first procedure is the intake. We want to know who you are, what's your name and your address, and additional contact information. We want to know against whom are you complaining. That's the respondent. What occurred, and why do you believe it occurred, and when did it occur? Because if we can get those questions answered, we can pretty much determine whether it meets the prima facie elements. So you would go through the intake process, and we would make sure that it was timely filed, that there was an act of harm, that the subject matter is jurisdictional, that is geographically jurisdictional, and we would then take your complaint, and we would draft the complaint and send it to the respondent based on what you're alleging. And this is just an allegation. It doesn't mean that it occurred. It's your complaint. You meet the criteria to bring it in. So what we are neutral fact finders. So we gather information. So we send out the complaint just as you stated it to us. And the respondent then has 30 days to articulate a legitimate, non-discriminatory business reason for their actions.
Is that done in writing?
It is. They can engage an attorney if they so desire. It's not necessary. Our process is an administrative process. It is not at the threshold of being in a courtroom. It's not taken under oath. You do sign an affidavit, the complainant, that to the best of their knowledge what they're sharing is correct. But the respondent can engage an attorney or just answer themselves, but the answer must be in writing and received within our office in 30 days. If they require an extension, they need to request an extension in writing. We also have a fact-finding conference. At the time that the complaint goes out, we invite both parties to come to the table, because our hope is that by bringing the parties together and discussing the issue, that we may at that time be able to resolve the issue. And sometimes it's even resolved before that stage, because more information has been gathered and it has been determined that it was a legitimate business reason. If it hasn't been resolved, we do have the fact-finding where we offer both parties the opportunity to resolve the matter and discuss whatever terms could bring it to resolution.
Now, when both parties come to the table, who is at the table overseeing this, if you will?
Typically, our investigator is the person that conducts the fact-finding conference, so it may be the investigator as well as a note-taker. So it is a tool of the commission, the fact-finding conference. So there's no objections, there's no cross-talking. The conductor of the fact-findings is asking questions. If the parties wish to ask the question, then it is addressed to the person who's conducting the conference.
So it sounds more like an informal conference as opposed to a court hearing where someone's under oath and answers questions and undergoes cross-examination.
Exactly.
Okay, so the investigator basically hears from both sides.
And this is because by that time, the complainant has stated what their allegations are. The respondent has had an opportunity to respond to the allegations. And so from those two varying stories, the investigator will have questions that they want to ask to try to just get a better handle on what's going on.
Okay, and then what ultimately happens after both sides have their say? What does the investigator do next? Well,
there's a process of gathering documentation, and all of this is going on simultaneously. There's been a document request that's gone out because most of the evidence is through documentation. So we're looking at documentation, we're talking to witnesses. So while all of this is going on, the investigator is still continuing with the investigation. And we have a proof formula, which basically we compare with all the evidence that we've gathered. And if in fact we can answer each question, it'll say proceed to the next question. So for every discriminatory act, say if it is hostile work environment or sexual harassment, there's a proof guidance for each act. If it's a negative action, such as termination or disciplinary action. There are proof guidances for every act that's covered under our jurisdiction. And we adopt that proof guidance from the State Human Relations Commission. So we follow their same proof formula. So we're not sitting back determining, is this true or is this not true? We're bearing up the evidence against the proof guidance, which basically says if you can answer this question with a yes, and then you provide what that evidence is, then you move to the next. And at the point that you can, the investigation ends and there's no probable cause. So we bear our information up against the proof formula and make a finding.
All right. So let's say that there is a finding that there was a discriminatory act.
Yes.
What happens then?
When there has been a finding made by the investigator, I will review that information, review the information in the case, review the finding, and I will at that point make a recommendation to our Board of Commissioners as to we believe that there is sufficient evidence to support a probable cause finding. We will issue an order of probable cause to the respondent as well as the complainant, and at that time then we'll set a pre-conference hearing just to move forward. We will try to conciliate the matter during that time after a finding has been made. You can still conciliate, and we have conciliated probable cause findings and not moved forward with a pre-conference hearing or a public hearing.
By conciliate the matter, you mean reach some type of amicable settlement to both sides?
Exactly. Once a finding has been made of probable cause, the evidence shows that there's been sufficient evidence to make that finding. So what we seek to do at that time is make the complainant whole. So whatever that would entail. And if in fact the respondent is agreeable to that, then we will conciliate the matter. If they are not, then we will move forward in our process, which is to have a pre-conference hearing and then go forward with a public hearing. Now, they may elect to go into common pleas court as well.
Right. So they can either have a public hearing at your forum,
yes,
or either side may elect to proceed with the Court of Common Pleas?
Exactly. And we have complainants who elect to go into court, and they usually will elect to go to federal court.
As opposed to the county
yes,
Court of Common Pleas?
Most complainants will do that. Most respondents will elect to go to,
I see,
make an election to the Court of Common Pleas.
Now, if they do not go to the trial court, then ultimately, though, a decision is rendered by
our board
by
of
your
commissioners.
board.
Yes,
okay.
We have a board of commissioners, and when we have a public hearing, 3 commissioners are selected by our chairperson to serve as motions hearing right, commissioners.
We're sort of running out of time
okay,
for our first segment, and we'll get back to that on our second segment. This is Legal Lines. My guest is Stephanie Seaton, Executive Director of the York City Human Relations Commission. Welcome back to Legal Lines. I am the host of Legal Lines, Tom O'Shea. My guest today is Stephanie Seaton, the Executive Director of the York City Human Relations Commission. And in the first half of the program, we were discussing the enforcement powers of Human Relations Commission. And Stephanie, what I'd like to touch on now is we ended at the first we ended the first segment by talking about the enforcement process, the hearing process, but ultimately a decision is made.
Yes.
And how is that decision then enforced if someone needs to do something to correct the discriminatory act?
Yes. Well, there is an agreement or a order which is enforceable through the county courts, the order that we put forth. So per our ordinance at the city, and then if it's not complied with, then we do have a commission solicitor who's able to then take it into common pleas court.
So it can be enforced by the Court of Common Pleas
yes,
of York County?
Yes.
And I assume then anything that can be done is also can be appealed?
Yes.
So both sides would have appellate rights on any determination that's made?
this is true.
Okay. And in general, I think what you stressed before was throughout this process, there's an attempt to reach some type of settlement, some type of accommodation to satisfy both parties.
Yes.
And can you tell us how successful that is with respect, do you have any statistics of how many cases are filed in a given year, and how many get settled, and how many go the whole way through the hearing process?
I would say, okay, out of roughly maybe 300 inquiries per year, that may result in 25 cases, actual complaints. So that's less than a quarter of all the calls that come in that actually result in a complaint. Of the complaints that are accepted, 85% of those cases are settled. And then there's 5%, there is 85% that's probably settled, and then 10% that we actually make a finding on.
Okay, so basically it sounds to me as though the investigator who handles these hearings, to a large part, is acting as a mediator.
Yes.
And trying to get both parties to come to some type of resolution without the necessity of going through the whole process with an enforcement process added on at the end.
That's correct. We do mediate a lot of issues, and the other 5%, sometimes for whatever reasons, complainants don't follow through with their complaint and they no longer want to continue in the process. But we resolve a lot of our cases, and of the findings that we make from that 10%, probably only 3% of those result in probable cause finding, and the rest are either settled or there were no cause findings.
Okay. And I'd like to point out that we spent most of the first half talking about enforcement, but you also have two other parts of your mission statement, and that is outreach and education. Yes. And both of those are very important. And let me talk first about outreach. What do you do as part of your outreach?
We engage in activities that are going on throughout the community as part of outreach. If there's a community festival going on, we set up display booths. We go wherever we're asked to go. We're in schools doing outreach and education. Our biggest outreach initiative has been the Unity March, which this year the Unity March is July the 15th, 10 a.m., Penn Park. And this will be the 10th year of that Unity March. Last year there were over 1,100 marchers, and this brings together individuals from all across the county in support of diversity, equality, and nonviolence. So that's our biggest outreach initiative, the Unity March. But again, we do several outreach initiatives throughout the year. This is April, which is National Fair Housing Month, so we will be showing a movie on fair housing entitled The House We Live In at the Strand Capitol Theater on April 28th at 6 p.m. and this event is free to the public. So a lot of the services that we provide in terms of outreach are free, and we are able to do a lot of this through a grant we received from the U.S. Department of Housing and Urban Development to do education and outreach in the community.
Okay.
So those are kind of some of our outreach activities. We do education sometimes as part of a compliance agreement. We'll go out and do education if there was a complaint, and one of the ways to help bring it to resolution and provide some public relief is through education. So we do education.
Now, by education, to distinguish it from outreach, I think outreach is basically making your presence known throughout the community, letting everyone know about the work that you do,
Yes.
and basically to go fulfill your mission statement, if you will. But then the education, it sounds to me as that's more directed toward individual companies or individual entities, businesses that may need some assistance in knowing what you do and how to make certain accommodations. Is that fair to say?
It is, and our education is based on our we look at our protected classes and that sort of subject matter, but we educate on issues of diversity, cultural awareness, sensitivity issues, sexual harassment, all of those sorts of things. And we have best practice models that we make available to businesses or to entities who want to be proactive and protect themselves against any future claims to make sure that they have a welcoming work environment and that it's free of harassment based on any of the protected classes. So we have had businesses to seek us out to provide this service. This is something we do as a part of our ordinance because we would rather provide education and be proactive, which we believe is effective in helping to eliminate discriminatory acts. That if we can educate and employers find this to be a benefit because you can say that you then provided this training to your employees and they have signed off on it, so they're accountable for the information as well. So we provide that service throughout the community. You only need to call and make the request because aside from having a complaint filed, we don't know what your needs are. So if the request is made, for example, we had an employer who was looking to hire his first female, and this workforce consisted of over 100 males. Well, they were worried about sexual harassment. So before they brought this female in, they called and asked, could we do training on sexual harassment? So we went in and we did training. We did an audit of the workplace to make sure there weren't inappropriate posters hanging around. So we can walk through. I've done walkthroughs for landlords or housing providers to make sure it's accessible or that there aren't things hanging on the wall that shouldn't be there.
Well,
so,
like for accessible, you're talking about people with disabilities?
Yes.
Because I think we pointed this out in the first segment, that the protected classes include individuals with disabilities.
Yes.
It includes gender.
Yes.
It includes sexual orientation. I'm probably going to miss some, religion, race. But also family size?
Yes, in housing it's your family size. And particularly the way our economy is right now, we've seen a lot of cases involving age discrimination, some retaliation, and layoffs, a lot of layoffs, and people believing they were based on discriminatory reasons. So those are all in our protected class, but we like to do education on these issues before something
So
occurs.
like if a company is looking, for example, to lay off because of the economy, which is unfortunately a sign of our times, they might come to you and say, what is the best way that we do this to avoid any discriminatory practice? We don't want to discriminate. We want to base this on other criteria, but we don't want it to appear as though it's discriminatory. And you would come in and give some educational program to such a company?
Sometimes it's just one-on-one in terms of whoever with human resource individuals. Unfortunately, a lot of people don't like to open up that area, but sometimes that sort of thing is done just through one-on-one. Our best practice models, and there are models out there that can assist employers in how to go about that so that it is not done in a discriminatory manner or a way that would appear discriminatory. So, but the broader trainings that are done for the whole workforce would be things along the lines of maybe sexual harassment or diversity training, cultural awareness, creating a welcoming environment in the workplace, being sensitive to the different religions that may be represented in the workplace, those sort of things.
Okay, so companies can contact you or contact the York City Human Relations Commission to have programs, either to talk to you individually or talk to someone at your office individually, or actually put on a program for the company, if you will, for employees, where there would be education with respect to your services and your commission.
This is true, and we encourage that because we continue to try to build relationships with the business community, the housing community, because working together, we believe that we can overcome some of the barriers so that everyone can have equal opportunity, that we can have diverse work environments that really are beneficial to the community at large, as well as to the businesses themselves. So we want to create an environment that is user-friendly to businesses, that we can provide a service and be a resource, because a lot of money is spent on training thus forth, but it may not always give you the law in addition to the diversity and the different aspects of the training. So we try to be comprehensive in that we want to give you a good model that you can use, one that is proven as a best practice, and that also ensures that you are in compliance, because I think you need both of those working together.
Well, number one, you're you're doing a good service to the community by participating in your program, and number two, you're avoiding enforcement problems that we
Yes.
talked about in the first segment.
Yes.
Now, one of the things that I'd like to point out is this is the York City Human Relations
Yes.
Commission. Is your jurisdiction limited to the city of York, or does it apply across the county?
Our jurisdiction in terms of enforcement is limited to the city. As I stated earlier, there are some exceptions when we are out in the county, but the decision has been made in the city, and most of those cases are housing. So we are a city commission. However, part of our ordinance states that we should seek the creation of a joint city-county human relations commission, because we believe this work extends beyond the borders of the city of York. This is not just a city problem, but that it would be of a benefit to the entire county.
And how likely does that appear right now, that it will go countywide?
Well, the discussion has been on the table for quite a while, and we need to have leadership step up and say, yes, this is something that we want for our community. There is a York County Interagency Task Force on Civil Tension, and this monitors civil tension throughout the county, but it has no type of enforcement. We provide technical assistance and education, but we are looking to provide protections for all the citizens of York, so that we can truly be that community that we're striving to be, and that would be a community that's welcoming, a community that's inclusive, that creates that environment that says, I can receive equal treatment, that there is equal opportunity for me here in employment, housing, and public accommodation. And whatever matters need to be taken to achieve that. I think it's worthwhile for the leadership to do.
Well, thank you, Stephanie. We're almost out of time. My guest today was Stephanie Seaton, Executive Director of the York City Human Relations Commission. This is Tom O'Shea, and this was Legal Lines. Thank you.